The order for Thursday, October 22nd. Glad to join all of you all. Certainly always welcome co-chair and Justice Earls. So I'll defer to her if she has any remarks or comments. Justice Earls, did you have anything that you wanted to speak
Not
of?
specifically. I do recognize we're beginning to be feeling like we're in crunch time, but I just want to appreciate all the hard work and let you know what how encouraged we are by the progress that you're making. So thank you for being here this morning, for all you're doing.
All right, thank you. All right, so with that, guys, of course, very appreciative of the hard work and the dedication that this work group puts in. Thank you for the support team. We have a pretty aggressive discussion agenda today, so we'll move forward. I think the good thing is that I'm not sure there are any items that we'll vote on specifically, but as we get into the various topics, if there are recommendations, we'll try to move those forward. So with that, I'll go to turn it over for asset forfeiture legislation. Ms. Leslie, would you like to start that item for us?
Yes, sir. Thank you. Good morning. I have a recommendation drafted up here for asset forfeiture, but before we get into the discussion about that particular issue, which I put first on the agenda, we have with us Elliott Abrams, who is our special guest, who's going to give us a 10-minute presentation, discuss asset forfeiture. He has been involved in some of those cases and has some thoughts on potential reform surrounding that issue. So without further ado, I'll turn it over to Elliott.
Great, thank you so much. And thank you all for all the hard work you're doing. I'm sure that this is one of many things on your plate. So on behalf of everybody who hasn't been seeing all the work that goes in, I wanted to thank you all for that. I have submitted a 5-page white paper as well as a 1-page kind of plan that's more focused or idea that's more focused on, what do we do if we get rid of the program that I'm talking about? How do we make sure that we don't have tremendous negative impacts on the budgets of law enforcement agencies as a result? And before getting into all this, it's my personal belief, and I believe that a lot of the supporters of this idea also believe that we get better outcomes, better policing if we have more money in the budgets of police agencies. And so, I'm very aware that issue, anytime we talk about taking money out of the budget, we have to figure out what are we going to do to replace it. And so first, just as a quick lead in, the program that I'm discussing here is the federal program called the Equitable Sharing Program. I'm sure everybody's familiar with it, but just very, very briefly, what that program allows state and local law enforcement agencies to do is to utilize the federal process to civilly or administratively forfeit assets in a way that would not be allowed under North Carolina law. And so just very briefly, under North Carolina law, there is no civil asset forfeiture. There is no administrative asset forfeiture. There's only asset forfeiture upon criminal conviction. And then if assets are forfeited upon criminal conviction, under North Carolina law, those assets go to the schools. So the feds have a separate program that basically allows state and local law enforcement agencies to circumvent that prohibition on civil and administrative asset forfeiture. And what will happen is state or local agencies will, for example, conduct a traffic stop and see, a bag of cash in the back seat, and they'll be able to seize it, keep it in their coffers, and then send a letter to a federal agency and say, hey, we'd like to use your process in order to forfeit this. Our state law doesn't allow us to do it, so we want to use your process. The assets stay with the seizing agency. A letter goes to the feds. The feds say, sure, we'll use our process. And then if that process is successful, then the law enforcement agency that seized it gets to keep the money. So that's not allowed under North Carolina law, but by using this equitable sharing program, basically state and local agencies are able to seize assets they otherwise couldn't seize under North Carolina law, and they're able to keep them rather than those assets going to the schools, which is, on its face, I don't think anybody has a problem with taking ill-gotten gains from criminals, right? That is a good thing to do. And so if the process worked well, then maybe, I wouldn't necessarily be supporting changing it if it worked well. But what we see with the equitable sharing program in particular is a lot of these seizures are very small amounts of money. And then the people whose assets are seized then go and try to hire a lawyer, and no one will represent them because there's not enough money in it. And so you have a host of people who lose their money, even if the money is legitimate, because they can't get representation in order to challenge the seizure. And under the federal process, the first step is a letter that goes to the person whose money was seized and says you have 35 days to file a particular document that has to be filed a particular way, has to be under oath, and you got to get it back to us in 35 days. And if you don't do that, you lose your money. And so those people go and try to hire lawyers. And if you've had $6,000 seized from you, a lawyer is going to say, look, you're going to have to pay me more than $6,000 to challenge this seizure. And so then they'll go from lawyer to lawyer, and eventually they'll either try to do this process on their own or they'll give up. And almost all, I don't have these particular stats nailed down, but my understanding is it's somewhere in the 70, 80, 90% range go through this purely administrative process where there's never a judge that reviews anything about the case. And so what happens, and I talk to these people, and one of the reasons I'm doing this is, I hate having to turn down so many people and say, look, if you had more money, I could help you, but you don't, and it's going to take so much time for you to get your money back. Here's the names of other lawyers that might be able to do this. And eventually those people just lose their money often, even when they have valid claims, even when the money's not criminal assets. And so what happens with those people in particular then is that they're upset. And it's like the folks that have gone to a restaurant and had a bad experience. They tell everybody they know. And so, for that $6,000, then you have this negative impact on trust in law enforcement that's just not worth the $6,000. And these are happening regularly. And what we see is that, the money that goes to law enforcement is not going, you're seeing these little amounts for most agencies and then big amounts for, the agencies in the big cities or the state. And so the total per year is $11 million across the entire state on average. That's seized and forfeited through this process. That's for North Carolina's 710 agencies, law enforcement agencies combined. And then most of the agencies that are doing this, all but 9 get less than 3% of the total money a year. So almost all the agencies are getting very little out of this program. And so, what my proposal is to say, rather than generate money this way, we should go to the General Assembly and say, you should increase budgets across. We're willing to give up this program. We don't get that much out of it, and there's problems associated with it, but you got to make up the shortfall. And you got to, and my thought is that that trade-off can get both sides of the aisle have a win for both sides of the aisle. So on the one side, we get rid of a program, and the piece I haven't shared, but it's important, is the statistics show that minorities are vastly overrepresented in the population of people whose money is taken, and particularly in these small seizures. And, you know, I don't question the motives that lead to that. That's just the outcomes that we see in the stats. And so I think it's a program that this particular group should be focused on, because we can take an issue off the table and say, we're not going to allow, you know, a bunch of people to lose money simply because they can't hire a lawyer. But, you know, it is a way, it's a practical reality that this is a way that law enforcement agencies add money to their budgets, which they desperately need. And so on the one side, we would say, let's get rid of this program and adopt an anti-circumvention law that 7 states have an anti-circumvention law. And what that says is basically our state and local law enforcement agencies can't use the federal equitable sharing program to circumvent state law. But in exchange, the General Assembly needs to recognize that by suggesting this, we're taking money out of our budgets. So we need you all to make up that shortfall. And so on the one hand, you have folks who will, I would expect on the left that would say, this is a good thing to do because we're getting rid of a program that has negative impacts that primarily fall on the poor communities. And on the Republicans can say, look, this is a way we can get Democrats to agree to increase law enforcement budgets. And so it's a trade-off that I think makes sense for, and I think, you know, when you think about it, it's $11 million across every agency in the state that's being given up. So, you know, the most any agency gets is not a whole lot of money. And so my hope would be that you could use this as a leverage point to say, you know, let's get more than we give up here. And let's give up more than we give up here because and then if we do this, right, if we get rid of this program, you're going to get rid of a set of interactions that occur between citizens and law enforcement that lead to people feeling poorly about that interaction. And I talk to those people and the people that call me generally know, you know, they're going to have proof of where they got the money. And I've seen countless times where they have the proof, but they just can't get a lawyer to go through this process to bring their case to court because it's just not that much money. It's a lot of money to them. You know, if $6,000 to an individual is a lot of money, $6,000 to the agency probably might not be. And those folks are the folks that go and tell everybody, you know, the police searched me for no reason other than to take my money. And nobody wants that. And that's really not probably what happened. It was probably a police officer believing that they had probable cause to believe that the money was the product of criminal conduct and believing that the process would sort it out appropriately. But the reality of the process, and it's not the state's process. Again, this is a federal process. It's got its own problems. You know, the burden is essentially shifted to the individual under tight timelines to come up with enough proof to get your money back. You know, that process has its own issues. We can't fix that process. And maybe if that process wasn't the way it is, it wouldn't be a problem to participate in it. But rather than participating in that process for a small amount of money that leads to, I think, a lot of folks believing questioning law enforcement's motives and driving down the trust of the citizens and law enforcement, let's say we'll support an anti-circumvention law, but you all, the General Assembly, need to put more money in our budget as an exchange for that. And I don't know, you know, I'm not a lobbyist and I'm not in the General Assembly, so I don't know, you know, beyond just, you know, thinking that this has wins for both sides of the aisle. Beyond that, I don't know whether that would be successful. I have talked to folks in the school system that they would get behind this, because if we're not using the federal forfeiture process, then they figure, well, maybe the law enforcement agencies will use the state forfeiture process more. And in my experience, there's very little use of the state forfeiture process, probably because it has more hurdles. But I would certainly support, and I think everybody that supports this idea would support, if someone has committed a crime and made money from that crime, they don't deserve to have that money. It's not theirs. You can't commit crimes, make money, and keep it. And so, forfeiture in general is one thing, but forfeiture where there's no opportunity effectively for most people to challenge their money being taken is a problem. And it's a problem that has disproportionate impacts on poor communities and minority communities. And I think we should use this as a way to say to folks who might otherwise be opposed to raising budgets, here's something you can have in exchange for supporting raising our budget. So that's the proposal. I'm happy to answer any questions to the best of my ability and do any follow-up in terms of trying to find more data and those types of things that folks think would be helpful. And thank you for your time and for listening.
Thank you so much. That's very useful information. I did have a question. As we'll ask those who are controlling the boards to let me know about any other questions that committee members may have. I know you said about $11 million a year is the dollar amount. How many instances on average? How many times does this happen on an annual basis? Do you all track that?
So the data that I have comes from the U.S. Department of Justice's website, and it does not break it down, at least that I've found. It does not break it down by actual incidents, but what I can tell you is that 167 agencies have participated over the last 3 years, North Carolina state and local law enforcement agencies. The smallest dollar amount is $127. And there's, if we start from under $10,000, there are 37 agencies whose participation led to the seizure of less than $10,000. So I think it's safe to say, if we're talking about those small increments, that it's quite a few times per year. I don't know how, I could probably try to come up with a better way to track that. But I think it's, in my experience, I'm one lawyer out of, Raleigh's got 1 million lawyers, it seems like. And so in the state, there's a ton. We get a lot of calls about this.
Yeah, I was just trying to get an idea about how many people were impacted. Like, I know the dollar amount tells you how much money comes into the process, but how many citizens on an annual basis are facing this challenge? But I appreciate, I understand what you're saying. Any other questions from panelists? I mean, from committee members?
Mayor Colvin, I've shared my screen here, which this was also included in the pre-work package that everyone received. And I have drafted 2 competing recommendations for your discussion. This is just taking a stab at things the committee might want to consider or not. So these are for your discussion.
Okay. So recommendation number 1 is to create some type of incentive for law enforcement agencies to not use the program versus working at some type of legislation that will prevent it. We have a couple of professional law enforcement. Fortunately, we have great law enforcement representation on this committee. Chief Davis or Sheriff Ingram, what are your thoughts on this presentation?
Well, it's good information to have, but I think it's a deeper story about the types of cases. And I'm not really that familiar with small level cases and assets, because that's not what I receive from asset forfeiture funds. most of the cases that my investigators are involved in, that's why they work on the task forces, because a lot of those cases are long-term drug enterprises and not just folks dealing drugs on a corner or, or something of that nature. So, to submit a recommendation that the state create incentives, that's a big ask. A lot of my funding from some of those major cases is significant. I could receive $100,000 from one case, and that's not a small group of people or a little man on the street selling drugs. That's an enterprise that we've taken down. That's probably taken several months, sometimes even a couple of years. So I don't know if we might be. I can only speak to my agency. I don't know that there are agencies that are receiving smaller amounts like that, which they probably could, and might be impacting, some person. $5,000 is a lot of money for an individual that might be caught up in a situation. But most of the awards that we receive from the work that we do are from long-term investigations. So I don't know, Sheriff Ingram, you have any more input on that?
Yes, ma'am. I've never been a fan of an agency being asset forfeiture driven. I've always cautioned our folks with regards to that, but at the same time, I think if I could not in good conscience agree to a ban with regards to the use of this program, because as the chief mentioned, it has helped us over the years dismantle very large organizations. When you start seizing assets and preventing them from being able to continue business as normal, it allows us to dismantle it in a number of ways. And while I do know of smaller cases or situations where, like Mr. Abrams mentioned, with regards to smaller amounts, that is not necessarily impacting just innocent people as well. There are occasions when you'll run across people involved in these organizations and seize that amount. And it is very effective in helping us further these investigations. So I've never been a fan of it. As far as I have seen some agencies over the year that would put together a group of officers that it seemed that their sole purpose was to seize assets, and that they weren't concerned so much about actually enforcing the laws. And I have always been adamantly opposed to that, and still am to this day. I do not agree with that. But at the same time, I know that this is an extremely valuable tool in our efforts to be able to dismantle criminal organizations within the state.
Chief and Sheriff, do you think that there's a middle ground there?
I do.
Just like if we were to enact some sort of statute, is there a monetary limit that allows you to go after the bad actors, but also accomplishes what Sheriff Ingram was talking about in terms of incentivizing folks not to use it for the wrong purposes, as he says he's seen? Is there something there to consider?
I agree with Sheriff Ingram, because even in the city of Durham, we don't allow our officers to do any type of seizures of assets, on the local level. The only seizures or assets that we receive, from a monetary standpoint, is from long-term, large-scale investigations. Seizures from vehicles that are used for trafficking large amounts of drugs from state to state, and cases of that nature. I do believe there are some problems that could potentially exist with allowing law enforcement officers. And I'm not as familiar as Sheriff Ingram is about the culture of law enforcement here in the state of North Carolina as it relates to seizing assets on a local level and using the state system or whatever for smaller amounts. I do see potential problems in that without there being appropriate oversight and cases that aren't involved in dismantling larger organizations. It might just mean that we need to do some work on how we what the language is for a recommendation like this. Like you said, Leslie, potentially some caps, because the caps will indicate that this is a large operation that does need to be brought down. Seizing $300 or $400 off a person on the street, that type of, even if that person is involved in some type of network, I still think there may need to be, some different types of guidelines. I think this one might require some work.
Thank you, Chief. Representative Gallagher.
I just have a question. I mean, this is a relatively, I've done my pre-work, but I just want to make sure I don't want to understand the history a little bit. Can either Chief Davis or Sheriff Ingram kind of give me a little of the history of what's lacking in our state law that would require law enforcement agencies to circumvent that state law? What is it that we don't have at the state level that would require law enforcement agencies to circumvent what we do at the state level? I guess that's the piece I'm not quite connecting.
Representative Gallagher, I'm going to yield to Sheriff Ingram, because in the state of Georgia, I wasn't as exposed to any state laws that prohibited federal, the work that we did as it related to, large cases. So I don't know, Sheriff Ingram, do you have any insight on that?
I do, and I need to apologize because I did not get to do any pre-work on this, and I was a drug officer for 12 years or so, and I knew the programs very well at that time, but I have since been disconnected from that, directly, where I can tell you the ins and outs of it. It's a very good question. I understand what you're saying. I love nothing more than when we use the state system to be able to take a large amount of money and go over and give it to the school board. It thrills me to death because we're able to support the efforts in our school systems here. We do it regularly. And there are some situations, though, where with regards to amounts that are needed, that we, with regards to how much drugs are found within a vehicle, and with that seizure, whether it's the vehicle itself or whether it's cash, or it could be other items that are seized, showing you have to show the connection that this is being used to facilitate this criminal act. There are thresholds that makes one easier to use versus the other with regards to these avenues. And a lot of times we're seizing, we only seize when we're working in connection with a federal case. So if the case is going federal, then we want to seize everything under that federal threshold as part of the evidence showing the connection to the criminal act, whatever it might be. And so that's normally why we take it on the federal side versus the state side. If it's a state case that we're working, then we just seize it under the state statute. And if the court deems that it's forfeited, then it's awarded to the school board. But most often it has the connection of whether you're actually working in conjunction with a case that's going to go federally, which is the state system. In our experience, now I can't speak for every other agency.
Representative Gallagher, did that cover what you were looking for?
I'm trying to connect all the dots. So just so I'm clear, when the state law is circumvented with this equitable sharing program, then is what I heard from Elliott that it could potentially result in a forfeiture of a person who was innocent and never convicted of anything? So does it allow us to then circumvent the state law that says you have to wait for a conviction to forfeit? So we can have forfeiture prior to the conviction when we circumvent, and then it results in some innocent people getting assets seized that now they can't get back. And so, Elliott, is there a way to give law enforcement what they need to do their job, and at the same time protect innocent people in the public that need to get their assets back? Is there a common ground on this, a way to do that?
I think so. And to the first point, you're exactly right, that the primary difference in the state law and the federal program that's being used here is the state law requires a conviction. The federal program does not. And so, I think under state law, and then the other difference is that under the federal program, the money goes to the law enforcement agency and not the schools. I think I think there's common ground on both of those issues. For one, you could say, yes, you can use the federal program if you get a criminal conviction, but you can't do it if you don't get a criminal conviction. The ins and outs of that we'd have to think through, but it would basically be saying you can't circumvent the General Assembly's requirement of a conviction before forfeiture is complete. It doesn't mean you can hold the money. Under state law, you can hold the money from the jump. If you see money in the back of a car and it's got cocaine powder all over it, and there's a scale, you can seize everything. You can seize the car under state law. You just have to wait until there's a conviction in order to forfeit it. And so I think there could be a way just to address that piece, which really would be the primary issue that I'm getting at, which is folks who just lose their money because they can't represent themselves effectively or can't get effective representation. And then on the other issue about where the money goes, I expect that the school system and the folks I've talked to who represent school boards, I bet they would support splitting some of the money if with the state agency and local agency, if it caused them to use the state program more. Because right now, a lot of the money is routed away from the schools, and because there's not an option through the state program for the law enforcement agencies to get anything. And, in a big seizure that took a lot of time and took a lot of resources, it makes sense that and probably it took just straight expenses. At the very least, I feel like the law enforcement agencies should be able to recoup their out-of-pocket expenses in a big, long-running program that led to a big seizure and not have to take the budget hit. So, I think the school system would be willing, because that would incentivize using the state process as well. But, I could be completely wrong about whether they would do that. I think that the argument to them would be, right now you're getting nothing out of forfeiture because it's going through the federal program, so you get zero. If we at least got to recoup expenses from the investigation, maybe we would use the state program more, and then the schools would end up getting more money. All these things are above my head. I think everybody on this call is 12 times more educated than me about all those issues. And that's usually the case when I'm talking. But, I do think there's common ground here that could incentivize people to use the state process or just require a conviction. Because again, in my view, forfeiture is an important tool. You can't, sending one person out of a criminal organization to prison and letting them have all their money and their houses and their cars isn't going to do much. If you start taking their money, that can really have an impact. What I don't want to do is continue down this road of where we have a whole subset of folks who are innocent, whose money's being taken, and it's basically, causing people to think law enforcement officers aren't properly motivated, which I just don't think is true. I think, law enforcement officers are properly motivated, but they have the ability to use a program that lets them take money that the officers may think is the product of crime. Just nobody ever has to prove it under the federal program.
So Representative Gallagher, you good?
Just one word, real quick, Mayor. Leslie, is it at all, and maybe this is not a question for Leslie, would we be able to amend state legislation that basically said when law enforcement agencies pursue the federal option and circumvent the state law, they are required to return assets if there is not a conviction? And then everybody wins. I mean, am I oversimplifying it?
So that's a good question, Representative Gallagher, and I don't know that I have 100% the answer, but I do have some thoughts. The thing that we have to consider when thinking about this is the intersection with federal prosecution. I spent almost 7 years as a federal prosecutor, and most of that time as the head of the narcotics section. And so in my experience in doing that type of work, a lot of the seizures under the federal asset forfeiture program ended up in what we call federal adoption cases. It's local agencies taking those cases to the U.S. Attorney's Office for federal prosecution. And if that happens, number one, when that happens, I think that alleviates Elliott's concern, because if there's a prosecution and a conviction, then that's not an issue. But that sometimes doesn't happen until on down the road a little bit. And I'm not sure. So that's one thing to think about. And so to your question, I'm not sure that we could enact a state statute requiring any federal entity to return money to us. But what theoretically we could do, we would need to research it some more, but we could recommend looking into putting a cap on the amount of money. We could enact an anti-circumvention statute, but put a cap on it saying that in North Carolina, we don't want law enforcement to circumvent the state statute saying that asset forfeiture has to go hand in hand with a conviction, but put the cap on that saying that, the seizures over 25,000 or whatever the number is that folks would choose is in fact indicative of, as the chief says, a large scale criminal organization and that kind of thing. I mean, I think it is true that most people don't drive around with $25,000 in cash in their car. I mean, I think that that's probably a dangerous proposition. So we could look at something like that if you're interested in doing that.
And the last comment I'll make about, I'm sorry.
No, go right ahead, Chief.
I was just going to say the last comment that I'll make about this is I think, years ago when federal task forces came about, it was because of the nature of the types of investigations that needed to be conducted that they crossed jurisdictional lines. And it's hard to prosecute a case in a particular jurisdiction through a DA if there isn't any collaboration with all of the other, counties. And the federal cases really can cross jurisdictional lines and can be prosecuted with more fluidity than on the state level. So I just wanted to kind of put that out there because it gets a little complicated when you think in terms of drug trafficking crossing not just jurisdictional lines, but also state lines as well. And a lot of large cases are built and dismantle large networks because that's sort of the nature of how those crimes are committed. So I think Sheriff Ingram, did you have something too?
I did. I did want to point out, and I was trying to remember all this, and that's why I had to go off camera a minute and talk with my folks. There is a process on the state side that you can seize civilly that we're not pointing out, that was not mentioned earlier, and that's under the North Carolina Department of Revenue unauthorized substance tax, where if a person is going to possess a certain amount of controlled substance, they can go and purchase a stamp that authorizes them to possess that amount, even though it's illegal. It's a very unique situation. But if they are found in possession of a certain amount of drugs and there are assets associated with it, it can be seized under um, that avenue. And in that process, the split is 70% of those assets go back to the agencies for law enforcement use, and 30% is maintained by the state to um, to facilitate that program. Whereas I think it might have been mentioned earlier that with the federal civil process, it's 80-20 split. So a lot of times, but again, you have to have drugs connected to the amount of or connected to this asset, whatever is being seized, whether it's cash or vehicle or whatever. So, you know, we have strong programs within the state to go after this. The thing that is unique about the federal side of it that was, I think, pointed out by Mr. Abrams was the fact that you do not have to have any drugs. You do have to show a connection. And if that person does decide to fight to get their money back, it eventually does go to it before a judge. The initial process, when they're given the days to respond, doesn't, but ultimately it does go back before a judge if they decide to fight for that. So I just wanted to point out so everybody has a good understanding of what is available to law enforcement within the state. I just see it problematic putting a cap on something. I think someone had mentioned like 75,000. That's very problematic, and we're ultimately it's not about seizing assets or seizing money or anything else. It's about getting bad actors off the streets. That's dealing poison to the people in our state and killing people. I want to remind everybody, we're in the midst of an epidemic with regards to addiction, which is the true war I humbly think we should be fighting, not a war on drugs, but a war on addiction. And we're having people, and we see it now, we're seeing an increase across the state in the number of people overdosing and dying. And it's from people that are dealing this and involved in these networks. And it may not be necessarily the kingpin that we encounter every day. That person may be in a different jurisdiction altogether, but facilitating this in our areas. And so we have to be very careful how we limit law enforcement's ability to dismantle these organizations. And these organizations are not necessarily huge organizations. They can be a much smaller organization, but still putting the poison on the street that's killing people day in and day out. So I just want to remind you what's at stake here. I agree. It should not be free reign, and we should never operate in that manner. But I think it could be, you know, something we're talking about could be included in the standards that we are suggesting with regards to the accreditation program that's been mentioned and discussed. But we have to be careful about something that may be used recklessly in other areas, or we may have had some bad experiences with. You know, I'd like to see some data showing just how many people, as the mayor mentioned earlier, have been impacted by this negatively in our state in recent times. And I don't have that. If somebody has that, I'd love to see it.
Sheriff, I did have a question for either Mr. Abrams or one of the professional law enforcement, just so I understand. So if the case is a federal case, as if it's the federal task force that's working with the local agency, does that require the local agency to choose the federal option of seizure? That's the first part of the question. And secondly, if the answer to that is no, then maybe the guidance is, because it sounds like the state has those safety triggers in there that says that a person has to be convicted, that it has a number of things. There's not many laws that local agencies can choose to circumvent and go around statute and use another one that works to their financial advantage. So is that a requirement based on what type of case it may be, because that requires them to either use method A or B?
I can take that one, Mayor. Oh,
Yeah.
sorry. So basically it is a choice. The law enforcement agency, when they are making an arrest and doing a seizure, they can choose to charge that as a state charge, or they can choose to charge it as a federal charge if they take it to the U.S. Attorney's Office and that is accepted. Typically, if it is charged federally, there is either a task force officer involved. Many local agencies in North Carolina have task force officers who work with FBI, ATF, DEA, and do these kinds of seizures. And it's usually involving a task force officer. There didn't used to be a prohibition against the seizure of money, against taking it federally if there was no federal involvement. But now I believe, and someone correct me if I'm wrong, the most recent change to that is that there has to actually be federal involvement in the case in order for them to take it federally. So either a task force officer was involved in the seizure, or someone from one of the federal agencies was working with hand in hand with the local law enforcement agencies to effectuate that seizure. So there is a choice certainly that the local agency can make based upon whatever they think is the right thing to do at the time. I'm not sure they can choose to take it federally, though. I would need to look and make sure that it's still the case that they can't choose to take it federally if there hasn't been some federal involvement in the case to that point. So sort of, yes.
Well, I guess what my question was more so geared toward whether the case is charged federally or not. I'm not getting into that part, because the professional law enforcement agency would know whether it needs to go that route. What I'm saying is that could there be some requirement on these North Carolina agencies that say that even whether the case is a state or federal, before you seize the funds, there has to be a conviction, to add that piece, not to get into the prosecution of it. So you're saying if the case is charged federally, then it comes with the ability or the requirement to seize it under the federal guidelines and not the states. Is that how that is set up?
It's not a requirement, but it is usually the case. Sorry, Sheriff, you go ahead.
I'm sorry. It's one of those days. There's a lot going on here. I think it's important to note that a few years back, we could seize under the federal law without a connection to a federal case. We cannot. North Carolina agencies cannot seize any assets unless there is already a connection to a federal case up front. So in reality, the federal agency that's working on that case is driving that seizure. They're the ones in control of that. So we've taken, really that problem has been solved. That reckless use of that at one time has been solved for the most part. So limiting our ability to work with those federal agencies is going to negatively impact our ability to dismantle these organizations, especially if you take our county, for example. We're sitting on the state line of South Carolina. So we work significantly or frequently across the lines with our law enforcement partners there and our federal partners in order to go after these organizations. And so I just want to, again, I want to caution us about attacking it from that way and limiting our ability to work with these federal agencies.
Yeah, Attorney General had submitted a something in the chat. Attorney General Stein, are you here? Would you like to speak?
I've been listening. It's been a great discussion. Very helpful. I mean, the problem I've always had with the seizure is the lack of due process, that the stuff seized, whether or not you ultimately get convicted or not. And so I don't know if there's some way And I think this is exactly what Representative Gallagher was asking is, can you limit in state law the rules by which state agencies participate in the federal program? And I think if there's some way to make the actual forfeiture the way that Elliott had mentioned, seize it, go ahead and seize it and keep it, but you can't actually forfeit it from the person unless there's a conviction. And that just seems to comply with my notion of American fairness.
Yeah, yes, sir. That was, you articulated it well, young Representative Gallagher, but that was kind of the crutch of what my question was. So is that an item that we will have to get research to see whether we can put that type of criteria in to that process?
It is. I think that's something we'll have to do a little bit of work on to see whether, to make sure that all of that could work out the way we would anticipate. So I would suggest perhaps if that is the will of the group, that maybe we table it for our discussion next week, and I'll do a little bit of research in the meantime.
And if I may have one comment on that, I think, the due process focus is really what caused me to want to bring this to y'all's attention. I think that a cap, so under state law 90-112 allows seizure and forfeiture of assets that are when there's probable cause to believe that they're connected to drugs. So the state law allows the seizure on the front end of drug connected assets. And so then the money's not with the potential criminal. And under state law, you have to carry through to a conviction. If there were a way under state law to say you can't participate in the equitable sharing program absent a conviction, that's one way to go. I think the cap of saying you can't use equitable sharing unless the seizure is of a certain amount may respond to most of the due process problems, because the due process problems are really an access to counsel, access to court problem. If there's enough money seized from you, and as long as we say the cap is adjusted for inflation, so in 10 years it doesn't become the effective cap of being really low, people are going to hire a lawyer if the seizure, if they're innocent and the seizure is of a certain amount. So if we put in a cap, and that would be to say this doesn't prohibit the seizure of money and forfeiture of money under state law. You can forfeit $1 under state law if the person gets convicted and you can show a judge at the end of the case, this dollar was made through drug dealing. So this wouldn't say you can't forfeit if you seize under 25,000 or whatever the cap is. It would say you can't forfeit it without a conviction if it's under a certain amount. If it's over a certain amount, then they're going to hire a lawyer to defend the civil forfeiture. And so we'll probably get in front of a judge. And so it would deal with the issue that I think is where you get the most negative consequences from this, which is those small seizures, while allowing, if there is $5,000 and that person is convicted in state court, that money can get forfeited as well. So we're not taking the ability of law enforcement to seize under that cap away. We're just saying under 25,000, you can't keep the money unless you get a conviction. If it's over 25,000, then we can feel comfortable that the person's due process rights are protected because there's enough money at stake for them to be able to get a lawyer. So even if they don't get convicted, they'll likely have access to the courts. I would say it would comply better with state law to say you can't do any of this unless you have a conviction. But there are cases where you have a big criminal organization that's so sophisticated that they're able to make it really difficult to trace the money and get a conviction under the high burden of beyond a reasonable doubt, to where you probably should be able to say, Judge, we can show it's more likely than not that this person's money is from drugs and we should be able to take it. Those things exist. But what my problem with this is not that money that's connected to crime is forfeited. It's just that money that's not connected to crime is forfeited because people don't get counsel to represent them because they can't afford it or there's not enough money at stake. So it's just that limited issue that I think is what's actually capturing potentially innocent people. And we could probably deal with that with a cap of saying you can't go and do the federal program unless it's over this amount. You can still forfeit it under state law if it's under that amount. You just have to get a conviction.
Yeah, we got that part. I think what I think this group's purpose is to make sure that the process is equitable. What you described is one portion of that, but that just means that the means are there to hire an attorney to get it. You still shouldn't have to give up half of your money in attorney fees if you're not convicted. So I think that we need to zero in on that part, not just the part that they'll have access to the capital to employ a lawyer to have the due process. If I'm not convicted of something, I shouldn't have to pay all my money in legal fees to get the other half back. And so whether I've got enough to do that or I don't have enough to do that, I don't think covers the whole gamut of it. But I think this is a greater discussion that work group, if you think that, because we still have 3 or 4 items to go, and I do have a hard stop in the 2-hour period we allocated. Do you think this is an item that you would like to get more information about, some of the statutory options that we could, or recommendations we could possibly make?
Yeah,
I think Sheriff Ingram was trying to say something too.
Okay, Sheriff, I'm sorry.
No, I don't want to cut off Representative Gallagher, but I do. I would love to see more information, number one, and I would certainly discuss this matter with the folks here at our agency and get some input from them. I just want to be very cautious moving forward if we're setting thresholds with regards to what potentially attorneys' fees would be. I don't think attorneys' fees should be driving those threshold amounts either. That concerns me greatly. So I just wanted to get that out there, but I'm definitely for more information on this.
Representative Gallagher, sorry about.
No, I just want to make sure that, I guess my lens is a little different on this. I want to make sure that we're not shifting the conversation, because I'm processing this issue not from a lens of stripping law enforcement from what they need to be effective to maintain public safety, not stripping them of their ability to have the support systems in place, the partnerships federally. To me, that was not this conversation, nor was this conversation about taking what a convicted criminal has been able to acquire illegally. This conversation was about innocent people not having due process, not having equitable process. And I just felt like this conversation shifted away from a very innocent group of people. Law enforcement should get everything they need to do a great job, and criminals need to pay for their crimes. But if I didn't do anything wrong and something got taken from me, I shouldn't even I shouldn't even need a lawyer to get my stuff back. Exactly. And so I really have an issue with that. And I just want to go on record that I think this conversation has gone in a direction that, in my opinion, that was not what I heard as the original issue.
And if I may, Mayor Colvin, the process exists regardless of if you have a lawyer. So built into the federal asset forfeiture statutes is the process by which, if you bring proof, if you fill out the form and you bring proof that this money is yours, and you can show that you just withdrew it from your bank account because you sold your house, or you sold your house and you've got a bill of sale and it's cash money that you got from your house. If you can show all of those things, then the process is there in the federal system, regardless of if you hire a lawyer. The crux, I think, of the due process is that most people can't work through the process without a lawyer because it's complicated. So I just wanted to make sure that you knew there is a process that exists. So if someone showed up at the door of the U.S. Attorney's Office and said, here's my receipt for my money, they'd look at that. They'd certainly work with them on that. But that doesn't happen most times. Most times you would want a lawyer to help you navigate the system. So I just want to make sure you knew there was a process.
All right. So, well, I think this is a great topic. I look forward. So is there a consensus, guys, to table this until we can get more information on it? I see head nods, but I don't have everybody on the screen. So Chief Davis, I see is a yes. How about Representative Gallagher?
Yes.
I'm
Okay.
a yes.
Okay.
Yes.
All right. Okay. Well, thank you guys. Thank you, Mr. Abrams, and
Thank you all
I'm
very
sure
much.
we'll have some questions. And guys, I have a few more questions that I'll probably submit to Ms. Leslie. So if you have a few more questions on this item, just submit them to her so we can be prepared for our next conversation. Item 2 are the no-knock warrant legislative changes. Ms. Dismutes.
Yes, sir. So I should be sharing now the screen. Let me know if y'all can't see it. This was the recommendation that we talked about last time. And Representative Gallagher, to catch you up on the discussion, we originally had in here in subsection 2, we had originally essentially banned, I can't remember what the language was before. I don't have it. It's from the other draft, but we changed it here to say that officers may not make entry without knocking and announcing, because it had been more of a ban on no-knock warrants. And as I think that Chief Davis and Sheriff Ingram both brought up, that there are certain situations where law enforcement needs to be able to have that ability to save lives, especially in hostage situations and that kind of thing. And I think everyone wanted to think about the statute, think about how we could make it stronger, but also there was a question of, unlike in the Breonna Taylor case where there was not a statute that specifically dealt with no-knock warrants, we have this in North Carolina, and it is there to essentially state our feelings on these issues. So in subsection 1, we had changed reasonably believes to has probable cause to believe. I don't believe there was much heartburn over that. And then for an unreasonable delay here, felt that that was perhaps a little vague and wanted to define that to make sure what is an unreasonable delay. We did not take a stab at defining that. That's something that could be left to the folks who are drafting up legislation. I think the question for the group today is, number 1, do we want to recommend a change to this statute regarding no-knock warrants? And number 2, if so, what is that? And then do we want to leave the fine tuning and the verbiage to the folks who would be drafting the legislation? So I think that's where we are for discussion and seeing if we want to send this on to the larger group.
Okay. All right. Well, I'll go back to work group. Any questions or comments about this? Okay. Chief and Sheriff Ingram, from a professional law enforcement standpoint, does this jeopardize or compromise your ability to do your job effectively?
Mayor, if I may.
Yes, sir.
Okay. I've been thinking about this, and probably in the last 20 years, we've only had about 3 search warrants that would have been considered what you describe as a no-knock. And in every case, that had to be typed into the search warrant prior to getting it signed by the judicial official, and had to be justified, the reasoning behind it. So without that, with that in place, I don't recall of anything using or being able to do that without that situation already in place. And so, with our conversation the other day, and I just did not recall it, I wanted to bring that up. And Leslie, maybe you know something that I don't with regards to the statute.
Yes, sir. So I think that was exactly the point, and thank you for saying that. That was exactly the point that I was trying to conjure in subsection 2. The previous subsection 2, the way it reads right now in the statute, is it just says the officer has probable cause to believe that the giving of notice would endanger the life or safety of any person. I think I brought up that anecdotally, most law enforcement agencies that I've ever worked with wouldn't do a no-knock without specifically writing it into their warrant and getting approval by the judge, because that helps the law enforcement agency on the back end know that they had approval to take the action that they were getting ready to take by a judicial official.
So I understood Sheriff Ingram to say that in the cases that he's utilized this, he writes it specifically in the warrant. You said that's not required. So from a professional law enforcement perspective, Sheriff and Chief Davis, do you think requiring that would be okay, just to make sure that that everybody, you know, is as thorough as your agency?
I think that would be fine. Along with Sheriff Ingram, I don't know of an instance where, you know, we have it written in our policies that we don't conduct no-knock warrants, period. And really, to tell you the truth, that's aligned with the state statute about no-knock warrants. And I think the way Leslie has edited here sort of captures those unique situations where if a person's life were in danger, officers would be able to enter without feeling like they have to go back to a judge. So the way it's worded here, did that answer your question?
I think so. I want to hear from Sheriff, and then also Attorney General had a recommendation too about adding another subsection with some legal language. But Sheriff, does that, if there were some requirements put in place statutorily to make all jurisdictional agencies do what you already practice, is that an issue on your end?
No, sir, Mr. Mayor. No, sir. I think when we're talking about warrants, and I think that may be the issue where we kind of got sidetracked on our last conversation. We're talking no knock, and I think that Attorney General Stein made that point the other day, and I didn't pick up on it, and I apologize, because that he was saying, you know, a criminal act in the process that we have to stop. This is addressing something different that we already have in statute. Again, I've never seen a situation where we've been able to do a no knock by our current general statute. You are required to get it put in the warrant prior to being able to execute that type of situation. And again, they are extremely rare in law enforcement, the use of them in North Carolina. I can't speak about other states, but in North Carolina, it's extremely rare. And in those situations, you know, still there's a lot of justification built in to ensure that that is the proper way to proceed. So I'm fine with that. I don't want to do anything, honestly, I don't want to do anything to the statute or add anything that may give someone the perception that there's a possibility of doing a no-knock without having it approved by a judge prior.
Okay, good. Let the Attorney General, he had a comment. Then I want to hear from Representative Gallagher.
Yeah, my only thought was is if there are two circumstances when a no-knock warrant would be permissive, one is what Sheriff Ingram was just saying, and the one or two or three instances in his career where he felt it was necessary to go to a judge beforehand because maybe he knew through listening to a wire that the house was just loaded full of guns, in which case he said, okay, I need a probable cause that, and probable cause on the front end that a judge concurs with. I think the other circumstance where I hear people saying it may be permitted is if they're outside and they hear something in the door inside that leads them to think that there's a hostage or somebody in there whose life is in danger. And so one is exigent and one is anticipated. And I just thought it might be worth putting those two in there. If you all don't think we want the exigent one authorized, then, and we only want it when it's authorized on the front end, then I'm willing to hear how that makes sense. But that was just what I was hearing of the conversation.
Understood.
No, if Sheriff and Chief, do you all, I know that it's rare, but am I right that the only two instances are where you would have some reason to know beforehand and you get a judge to approve it, and the other would be some exigent circumstance on the scene that leads you to fear for someone's safety?
Attorney General, I think it's solid the way it currently is, but let's take this one scenario and kind of combine what you're saying. Let's say that I have a warrant, a search warrant in place. It's not a no-knock. It's just a standard search warrant to go and search for records in a house. And we approach the house, and before we knock, an officer can observe a person with a gun to another person's head that we had no knowledge about whatsoever. It appears that it looks like someone's getting ready to try to take the life of another person inside of that residence. So we have two situations there unfolding simultaneously, and I think we have to go with the situation unfolding and go without knocking. We would no longer, in my mind, necessarily be executing a warrant. We would be trying to prevent someone from killing someone else who's in the act of doing that at that moment. If that makes sense, the scenario I'm trying to give you. So I don't know that.
You're saying that the life saving doesn't have anything to do with the warrant.
I'm worried about blending the two in the same context, if that makes sense.
Yeah, you're saying somewhere else in law you have authority to enter a premise to save somebody's life, and it's not in the context of the warrant itself.
Yes, sir. And I'm concerned that if we blend this in this statute, it could lead to misuse.
Mm-hmm.
And I don't want to see that because it's very solid currently.
Well, then maybe we should just put in the bit about making sure that a court agrees that there's probable cause. If all we're talking about is on the front end, because the current statute doesn't reference that. It leaves, the current statute says that the officer has the probable cause, whereas what we're talking about is you're getting the warrant. If you have probable cause to believe somebody's life would be in danger, then go ahead and get the judge to agree with you. Because isn't that what you do right now?
Yes, sir. Yes, sir. If we have a reason to believe that justification for no knock exists, we have to naturally provide probable cause of that. And it's in rare situations, like you said, if we think someone's heavily armed and has made statements, or we're picking that up from a wire or whatever it might be, that they are looking for law enforcement and plan to try to kill them, then naturally we would build that into the warrant. But again, that is extremely rare. I can't even tell you the last time we've been involved in one.
Chief, do you agree with that? Like, would you ever do anything other than getting a court approved warrant that gives you the permission to go in without a knocking?
Absolutely. I think if there's already enough information that a location presents some type of, based on probable cause, that it presents some other type of danger to officers or even a third person, that we would put that information in the warrant in the first place. But I do agree that we might be sort of mixing what an officer can do on a normal day anyway to save a third party's life in a situation that we had no idea that this was going to arise. And we're not just really talking about somebody with a gun at another person's head. There's so many scenarios that kind of play out sometimes when you get to the location that something else is happening, but officers already have the authority to act in exigent circumstances when they can articulate, what it is that they were responding to. So what I don't want is, like Sheriff Ingram says, for us to put language in here that sort of gives officers another, reason to say, I did it because it was exigent circumstances, and the statute says I can do it because it was exigent circumstances. That could really open up sort of a can of worms. So the statute was.
Y'all are making sense to me.
So can everyone see the changes that I've made here? A couple of things. It's interesting because I think when people look at the statute without looking at the entire section, the entire chapter, sometimes they don't understand that entry by force they're talking about search warrants here, that it is within the search warrant chapter. So if we made an edit to clarify, just to make sure that everyone understands that, it might be unnecessary, but I've put that there for your consideration. This was the change that we made last week that I think no one had an issue with. If what I'm hearing you, and correct me if I'm hearing everybody wrong, there is a desire to say that officers can only make entry in a search warrant without knocking and announcing if probable cause to believe that giving them notice would endanger the life or safety of any person is presented to the judicial official who issues the warrant. So it seems like in practice, that's what Sheriff Ingram says happens in practice. And my anecdotal evidence also says that when seeking a search warrant, specifically law enforcement would seek a no-knock warrant if they believe that that's what they're going to want to do. We would take this out. This was the change we made last time. This is what the statute currently reads down here. And then we could go one further to clarify that this provision only applies to the execution of search warrants. That way it's clear, and maybe we don't need it up here if we've got it down here. But that alleviates two things. Number one, the chief's concern that we might have officers who will try to justify actions to say, well, it was exigent circumstances and I really could do whatever I wanted to do. But it also makes clear that the officers are covered by presenting their probable cause to a judicial official for a no-knock warrant. I think that's what I've heard everyone talking about. Y'all correct me if I'm wrong. I can take this section out if that's what you believe.
Leslie, I think I just, as a legislator who has drafted many bills, I have some drafting suggestions, but there's no reason for us to have that conversation right now. If what I heard was what you just articulated, the sense of the group, I think you and I can talk offline about how to execute that and bring it back next time, if that's what the working group wants.
Mr. Mayor.
All right. Yes, sir.
Leslie, please refresh my memory on subsection 1. Changing the language, the current language is reasonably believes, is that correct? And we're changing that to has probable cause to believe. What was the thought process behind that?
Strengthening, I think the thought process was, to the best of my recollection, strengthening what we want officers to consider when they are entering by force after they have knocked and announced. So this subsection 1 is after you have knocked and announced, like you're required to, if you have probable cause to believe that you are being denied admittance or unreasonably delayed, then you can enter by force. That's essentially what number 1 says. And so previously the statute read reasonably believes. And so it's a strengthening of that language. I think it's a policy statement, right? I mean, I think it's a policy statement that we want officers to have probable cause to believe, as opposed to just reasonably believe, which is going to be a lower standard than the probable cause. So that was the thought process on changing that there. It doesn't mean that they have to take it to a judicial official. That's not within that section. It's just that the officer in their mind have to later, if questioned, be able to articulate the probable cause that allowed them to believe that their admittance was being denied or that there was an unreasonable delay.
Okay, a scenario then, if I may, we approach a residence and we knock and announce, we're waiting. We hear movement inside the residence, but not towards the door. And then we hear something that sounds like a flushing noise, like maybe a toilet is being flushed, but we don't know that for sure. So does that standard require us to know that for sure before we enter? And from my vast experience with this, most often when we're hearing that, they're flushing drugs just as hard as they can flush them, the evidence of the crime. Is that going to allow attorneys the opportunity to get these warrants thrown out of court left and right? Because I can't say 100% that was a toilet flushing. It sounded like it, but I didn't have probable cause. I didn't have information that would rise to necessarily to the level of probable cause. But in my training experience, I reasonably believe that.
Well, Sheriff, to me, and again, you're talking to a career prosecutor here. To me, if you hear the flushing sound, that's probable cause, right? I mean, that you are being.
Well, and
probable cause isn't beyond a reasonable doubt, right?
And, you know, being a prosecutor, you also know what they're going to say. Well, how do you know that was a flushing sound? Well, it sounds like it. I want to make sure I think we're trying to make sure that we're not conducting warrants and prevent that situation. But at the same time, are we cutting our nose off to spite our face, so to speak? I just want to make sure that we don't set ourselves up for failure in being able to accomplish what we're really after here. And our statute really does. I mean, if you look at the current statute without anything else in it other than adding that, you know, applying to search warrants, it's really strong. You don't have the opportunity to just go and break down a door unannounced in this state currently.
And I think that the question for y'all to consider as the experts, you know, you, Sheriff Ingram, and you, Chief Davis, the question to consider is the scenario where you've got one knock, one yell police, and then there's broken in, right? And then you break and enter. And so I think that defining unreasonable delay down to number 3 helps with that. But I think that at least from the public feedback that has been received, that is the area of this type of enforcement that folks want to talk about. Folks want to talk about, what about when you knock one time, yell police, and then break down the door all within the same movement? And we know that that's not what law enforcement's trained to do, but I think anecdotally, perhaps it happens and people think it happens. And so is there a question there that needs to be discussed surrounding that part of this type of enforcement?
Well, and I understand what you're saying, and that is a very valid point. Let's don't say that doesn't happen, but are we trying to legislate a policy violation that could be handled? Again, I go back to our standards within our agencies need to be brought up, and we need to be held accountable at that first level. there needs to be more accountability. Please don't think that I'm trying to be difficult on this, because I do not believe in no knocks. I mean, I have a very good friend that is still with us, thank God, that was shot in the neck on a search warrant and lived to tell his story. But so I'm very cautious when it comes to this.
I would agree that warrants, those situations are just very dangerous. The first female police officer that died in the line of duty in the city of Atlanta, a friend of mine, was killed during a warrant. So I agree that I know we're responding to outcries about eliminating no-knock warrants and whatnot, but I do agree that our statute has provided some guidelines that I think are safe guidelines, and even with the edits that have been made here, I think we can move forward without taking too much away, because there's so many scenarios that we can't possibly capture. You know, in these conversations. And my question is, when these recommendations go forward, is it going to be enough that we haven't completely eliminated, you know, no-knock warrants? Because if it took us this long for us to have general understanding, I think those individuals who want this and that we have to respond to, it's going to take a lot for them to really understand the breadth and the complexity of warrants in law enforcement. So just based on what you have here, I think we could move forward with it without doing too many edits to the current statute.
So Chief, let me see if I can capture what make sure I'm understanding. So I believe if we took out this change here, changing reasonably believe has probable cause, and perhaps left that for a different day or a different conversation.
Yeah.
Oops, that was the wrong thing. Then we're left with section 1 doesn't change at all.
Please.
I think that there's no debate about defining unreasonable delay. I think that if we add a section down here to define unreasonable delay, that does help to get some, you know, what the public is concerned about is the one knock, one announce, bust through the door issue. And I think that the reason why I have an ellipsis here is because there's probably some case law that defines it that we can put into the statute or not, or change that. But I think that would be something we would need to look at, the drafters would need to look at a little bit further. That doesn't seem to me to be particularly controversial to the working group. And then here, the old subsection 2 is what I have stricken here. And then we've changed the new one to reflect what I think the discussion has been, is that the sense that we don't want to do no knocks without having a judge sign off on it first. But this is limited to search warrants. This only applies to search warrants. Am I capturing the will of the group there?
So then so this wouldn't apply to arrest warrants? Where are arrest warrants and what are the requirements of that?
I knew you were going to ask me that. Let me pull that up. It would not apply to arrest warrants. Those are going to be...
While you're looking for that, Leslie, I'd like to ask Chief and Sheriff, in your mind, were you thinking anything different between an arrest warrant and a search warrant? I was just thinking of any warrant. Are you more likely to do a no-knock on an arrest warrant, or do you use the same standards that you used on the other ones?
Well, you know, those arrest warrants are, you know, just as, you know, complex too, in nature. I was thinking and you know, I see it right there in my face, search warrants, but for some reason I was kind of thinking we were talking about both. I'm sorry. But Sheriff Ingram, if you chime in, I mean, arrest warrants can be just as dangerous, especially when you're going after somebody who's wanted for a felony or something of that nature. But then, of course, that would require you to articulate the probable cause for a no-knock to a judge for an arrest warrant because this person has already proven to be dangerous. He has guns and la da da da. But you can still get there if you don't have a no knock, and some of those same scenarios that we were talking about before could present themselves. So the language could be very similar.
And I think it is. Can y'all see this? I pulled up the statute here. This
I need
is
to put my bifocals on for that.
This is the use of force and arrest, and then entry on private premises, vehicle use of force. It's when the officer has given or made reasonable effort to give notice of his authority and purpose to an occupant thereof, unless there is reasonable cause to believe that the giving of such notice would present a clear danger to human life. And then the second part of that is law enforcement officer may use force to enter the premises or vehicle if he reasonably believes that admittance is being denied or unreasonably delayed, or if he's authorized under previous section to enter without giving notice, E1C. So essentially E1C, which is right above 2, is the no knock provision for arrest.
Mm-hmm.
And then 2 is without giving notice of authority and purpose. So 2 is the no knock provision.
So I have a quick question, Leslie, while you're looking that up for the law enforcement professionals. From a policing procedure perspective, in terms of your policing procedures, do you have different procedures for how your officers execute a search warrant versus a arrest warrant, or procedurally is the process the same?
Actually, their general orders or procedures or policies that sort of guide on either one, you know, because they both present different types of situations sometimes. So we do have a general order that guides on arrest warrants and one that guides sort of a subsection that guides on search warrants as well. Sheriff Ingram, is yours that way?
Yeah, we have very strict policies with regards to ensuring that when you're serving an arrest warrant or executing a search warrant that, you know, with compliance with the law. But with regards to search warrants, there is a tremendous amount of pre-planning.
Mm-hmm.
We require ops plans that detail everything that will take place to ensure safety all around for everyone involved. There's extensive planning in that. But if you think about arrest warrants that are coming in, and we have, in our agency, we have warrant officers, and that's all they do day in and day out. I was a warrant officer when I started earlier in my career. I was tasked with that. And it's the vast majority of people you encounter are a lot of repeat folks that we had with these warrants. And we would just go and go to the person's address, knock on the door, they'd come to the door, or they'd run out the back door. And, you know, it unfolds much differently than a search warrant. A search warrant is something that we can control. Ultimately, we can serve it or we don't have to serve it. With an arrest warrant, we have to serve that. And, you know, if we go to a residence and we see a person in that residence and they're not coming out, while looking at the statute, we would have authorization to go in. We try to ensure that we don't endanger someone else unintentionally by serving that arrest warrant and just proceeding and kicking the door in, for lack of a better way of putting it. And because there's so many variables inside, and we don't want to put our officers in harm's way either, because we don't, again, there's so many variables inside when it comes to that. So we look for, you know, the approach that will, we look at to be able to deal with these situations in a way that would be the safest possible solution each time we approach that for everyone involved, not just officers, but suspect or unknowns as well. And So arrest warrants are very different, but again, I don't know of a lot of situations where they're able to kick a door in and go inside and serve an arrest warrant. That's just not happening in law enforcement that I see around here. Actually, I see more of that occurring with bondsmen kicking in a door and going in and grabbing people. That happens frequently. So, I want to be careful with these moving forward because I see how we could go into an area unintending to do so and create more problems or get it to a point where it could be interpreted one way or the other when we have very good statutes regarding that now. And they're solid. I mean, of course, with a little bit of language strengthening in, but I don't want to go into that area where it gives officers the belief that, if they articulate something one way or the other, that it gives them much easier access to be able to kick the door in.
And Representative Gallagher, there is also a legal distinction that we need to think about when talking about arrest warrants versus search warrants. The arrest warrants are only going to be served, and therefore that force is only going to be used after either a grand jury or a neutral and detached magistrate has found that probable cause to charge this person with a crime. And of course, if it's the grand jury, you're going to have an indictment that precipitates the arrest warrant. So it's a little bit more of a certainty that the person you're trying to find and is in fact the person responsible for the crime. Whereas with a search warrant, it's a very investigative tool, as you know, and it could be on the very front end of an investigation. So I think there is a legal distinction there. Also, looking at the statute, it looks like in the arrest warrant statute, they use present a clear danger to human life, which is stronger language for the arrest warrant than is currently in the search warrant. Clear danger is stronger language than would endanger the life or safety. So from a legal perspective, I think that if we're strengthening the search warrant statute, I don't think that we're endangering perhaps the arrest warrant statute. And maybe they do serve two different purposes.
I agree.
All right. So work group, where do we leave this one? Where are we going with it? We've had a lot of discussion both ways. So
So here's what I have currently, if everyone can see the screen. Removing what's in yellow, and essentially what is new is the blue would be new. We can take this out. I think we know what we're talking about here. Defining unreasonable delay. Maybe making it clear that this applies to search warrants, although it is in the search warrant chapter. And then making it clear in either this language or some version of that language that a no-knock warrant needs to be signed by a judge. And I think that is what we would need to vote on, if that's what the group wants to discuss.
You have a question, Representative Gill?
I do. I just want to understand from the chief and the sheriff the significance in terms of your overall body of policing a no-knock warrant is. And so I'm just wondering, I think in all of our situations, we could potentially have a leaning to protect something that when we really look at it from the overall body of what we do, it may not really be as significant as what people may think it is. And so I'm not a law officer, obviously. And so I'm just wondering, from your day-to-day operations, I mean, how often are you really, is a law enforcement officer required to enter into a place without knocking? I mean, is it really happening that much? What are you going to lose from a law enforcement perspective? And what do we lose from a public safety perspective if in North Carolina we just didn't do no-knock warrants? Hopefully that question makes sense.
Yeah. For me, it's sort of like, some of the other areas of our work. It's like you may not use it you may not use your weapon in your entire career, but when you need to use it, you really need to use it. And that's kind of the way, not just with no knock warrants, there are a lot of, tools in the tool belt and policies and guidelines about situations that it could happen where you really need it to answer your question. And to eliminate it could really tie our hands in a situation where, and I know people, a lot of folks are screaming about eliminating but I think what has happened is that there were some folks that obviously have gone out on warrants that didn't have the policies and the procedures and the preparatory work that, Sheriff Ingram mentioned. That's really critical to have in order to effectively and safely, utilize these tools that we have. When he talked about pre-planning, and I think that's what we need to focus on, even through the North Carolina Commission. Leslie, we have the opportunity to make sure that our agencies have certain policies and procedures in place for pre-planning for these types of, situations. So I hope I answered your question okay, Representative.
No, you did. I just think it's important as we deliberate these really significant issues that we verbalize what we know some of the community concern is. And I think sometimes the way we approach it is more from a let's do as little as we have to do versus going all the way to the other side saying, hey, listen, we know as a community, this is something that you'd like to see happen. Here are the reasons why we really can't make it happen. So I think it's just important that that's a part of the conversation.
Yes.
So thank you.
And I think too, Representative Gallagher, I'll come to you in just a second, Sheriff Ingram. I think that's the beauty about the balance of this work group, that, from a professional law enforcement standpoint, of course, they're going to look at things different than you and I, who try to represent the citizens, the constituents that we have. So I think that provides good balance. I'll go to Sheriff Ingram, and then we'll see, guys, if we can come to some consensus on the changes for this one. Sheriff?
Yeah, thank you. And I just wanted to mention, again, as the chief said, that it's rarely used, but when we use it, it's something that we certainly need. As I mentioned earlier, in 20 years, we may have used that 3 times in 20 years. But again, if you look at the use of that, more often than not, even with all of the preparation and all of the intel work that we do up front in dealing with search warrants, we're going into the unknown so many times. But on that very rare occasion when we get really good intel that, hey, this person is armed, ready to go, and they have made numerous statements that they're going to shoot or try to kill law enforcement if they come after them for whatever reason. And in that situation, if all other means are exhausted, it gives us an opportunity to go in a situation like that and potentially save lives rather than costing lives. And that's the approach that we take. We look for the opportunity to be able to save lives and not jeopardize innocent people or the suspects or officers as well. I mean, it's just, as the chief put it, you don't need it until you really need it. And I think that understanding that and having these conversations, I think, is great. I do. And I see if you think about it, 3 times in 20 years, it's hard to justify a real need for it. But as the chief mentioned, it's just like your weapon. You go a career without ever drawing your weapon, and thankful for it. But if you have to, you really need it. And I think that applies as well.
Thank you, Sheriff. All right, group. Where are we on this particular recommendation?
I'd say move it forward with an explanation.
Okay.
You know,
All right.
I really believe that there has to be an educational component here. You know, people are not going to get it if we don't make sure that we share with them. And Leslie already said it, maybe some case law, some situations that if you put yourself in that situation, I would want somebody to knock my door down if somebody had a gun to my head. I just think that there are ways that we should be able to socialize this to our audience and to our community members that, you know, may need to understand the why.
Agree. All right, so guys, is that a consensus to make the changes that we've talked about? I guess Representative
with it.
Gallagher, you
I'm
good?
good.
Chief
Yes.
Davis,
Yep, I'm good with it.
Sheriff Ingram.
Yes, sir.
All right.
Mayor. Chief, this is Jasmine. I just think we could use the problem statement very creatively here to do some of that work that you were identifying. I think that's very
Thank you,
possible.
Jasmine. You've been too quiet today, Jasmine.
I've been listening, I promise, very closely.
Okay.
All right, guys, we're body cams. I'm sure that's going to be a pretty extensive discussion. Not sure if we can get our arms around that in a lot of time left. Any recommendations on how we handle?
Mayor Colin, if I can make a suggestion, I think we
Okay.
do need to vote on the no-knock so that we can at least vote one thing out of committee today to go to the straw poll for the November 6th. We do have meetings scheduled for next week, and we can schedule another. We're going to have to schedule additional meetings, I think, to get to the majority or the remainder rather of our topics. But I think with the 10 minutes we've got left today, it might be useful for me to go over with the group what we have left, and that way people can start thinking about it, and we can really jump right in when we have our next meeting, if that works for the group.
Okay.
You know, next week we can jump right into it.
So the consensus we took on the no-knock, you need a formal vote?
Yes, sir.
Okay. So, and then I'll come to you to kind of recap on the things that we have coming. All right, guys, can we get a motion to approve the changes that were, as presented for the no-knock?
I make that motion that we approve the changes for the no-knock.
And I second.
Okay. All right, so there's a motion by Representative Gallagher, and a second by Chief Davis. Any discussion on the motion? All right, all those in favor, hands. All right, motion carries. Ms. Dismukes, it's in your hands.
Yes, sir. Thank you. So the remainder of topics that we have to discuss, and I think that are things that we should really spend a lot of time on, are body-worn cameras and our recommendations to the standards commissions, and which is also kind of addressing what folks call colloquially the wandering officer issue. And I've got this here you have in all of your pre-work. So you already have all the pre-work that'll be necessary for next week. But to go over some of these questions so that you can start thinking about how you as a group want to discuss them and what your preferences are. Under body-worn cameras, I've only made one recommended solution, and then I've posed a whole bunch of questions to talk about other solutions. So the one recommendation I've made is consistent with what has passed out of committee for the personnel laws. So I've put here, recommend drafting legislation to amend this statute, which is the law enforcement reporting statute, to include civilian oversight boards and city and town council access to those recordings in line with our amendments to the personnel laws. But again, noting that only the registered civilian oversight boards or city or town or county councils can gain access. And then noting for this group that the statute itself already states that the documents are not public records or personnel records, so we don't have to include that revision. And then again, with the non-dissemination, the viewing as opposed to being able to disseminate. And this recommendation would be completely consistent with our recommendations for civilian oversight boards and the changing of the personnel laws. So that's the one I felt comfortable drafting up for you guys to consider. Of course, if it's absolutely not objectionable at all, we could vote it out today, just this one recommendation, and discuss the rest of it next time. That's up to the group. The other
So-
issues, though, I'm sorry, go ahead, Mayor.
Yeah, before you move on to that, you said, I know a registered COB, we talked about that. What do you mean a registered town or city council? They're elected,
They're
right?
just registered COBs or city, town, county councils.
Okay.
So
All right.
in other words, an entity recognized by the municipality as legitimate.
I got you.
So the questions to consider that I think this group needs to decide are, one is there ever a scenario where these videos should be automatically released? And you can read in some of the pre-work, and John Paul actually put together a great staff memo that's not too long for y'all to read and kind of consider part of that issue, bringing together some expert ideas and also some examples from other jurisdictions. But is there ever something like a critical incident trigger? And I believe maybe it's New York that within 30 days, you have to release the camera footage, period. But that 30 days is time to do things in the investigation and that kind of thing. Does North Carolina want to consider something like a critical incident trigger in that scenario? And if so, who gets, who's it released to? When does it happen? Can victims or their families have the right to object? That's something to really think on. Then the next kind of area is, should we either commission a study in North Carolina regarding the effectiveness of body-worn cameras before making a recommendation to mandate them? Or do we feel strongly that we do want to mandate body-worn cameras given the large number of law enforcement agencies that already utilize them? And if so, then number 3 is, what are all of the things that we need to answer? Who should wear them? Patrol, detectives, command staff. When should they be worn? What exceptions should specifically be noted for when they should not be worn? For example, talking to a victim of a crime or talking to a confidential informant, that kind of thing. What accountability structures already exist in agencies, and are they being used properly? Should the public have input into this question? And should there be penalties for failure to comply with any body-worn camera law that we recommend? And then what about other types of recordings like dash cameras? Should those fall under any body-worn camera discussion that we have? So I think it's a lot to think about for this group, but the more pre-thinking you can do and being ready to kind of tackle this from jump when we get to next week's meeting, I think would be helpful. So, if there's a desire to pass this recommendation as drafted here, this top one, just number 1, not all the stuff in bold, then we could consider doing that today and send that out to the straw poll and get that moving along with the Civilian Oversight Board, since it really kind of goes with that. If the group doesn't want to consider that, we can move on, and I'll explain the other things to think about for next week's meeting. So I don't know how everyone feels about that.
Well, what do you think, group? I think that all of these things require some level of discussion and questions, but I'll certainly follow the lead. I mean, I would hate for us to do something and not have completely talked it out, but I'll follow the lead. What is you all's opinion about that?
For question number 2, I wholeheartedly believe that all agencies should have body-worn cameras. I think that has been sort of a fiscal issue for some agencies that haven't received body-worn cameras, but they're grants and all kinds of. Are there small agencies or something in North Carolina that have not moved to body-worn cameras yet?
There are, Chief. And so I think, and I may have confused the group, and I apologize for that. So when it says questions for the group to consider 1 through 3, I think all of those are questions for next week's meeting because they're so complex. My question to the group was, number 1 is a recommendation regarding the access to these recordings. So it was a question as to whether or not you wanted to move that forward with the access to the Civilian Oversight Board's access to personnel laws, which we've already passed, or whether we want to table that, which is also fine. We can discuss it next week. I just didn't know because it's essentially the same recommendation we have already passed for personnel records. It's just this recommendation and I think Sheriff Ingram wants to say something about it.
No, I was just going to ask, what does access mean?
Yeah.
So I think hopefully if number 3 clarifies that, they can review but not have copies or further release. It's the same. I cribbed the language from the other Civilian Oversight Board recommendation that we passed. I took the exact same language we used there for that purpose, for that very reason.
And that's what I was getting at. And I didn't see that part of it, but thank you for pointing that out. And I think it must contain that language because we have to protect that. And
if everyone wants to think about it, I think it's completely fine for us to discuss it next week. And we can I'll tee that up. And I think that Representative Galliard's giving me a heads up on the thumbs up on that. Asset forfeiture recommendation. Then also the recommendations to the standards commissions. And, Chief and Sheriff, I think y'all can noodle on this, both being on the commissions. I think it will be important to have your really thoughtful feedback on these questions. So the first recommended solution would be to recommend support for the wrap-back program. Then that has been voted approved already by both commissions, but now it's in the posture where it requires legislation. So the task force has an opportunity to approve that or to also state its support for that. I've provided information about the wrap-back program in your pre-work literature, so you can take a look at that for next time. Then the second one is to recommend revisions to the minimum standards, and these are the two statutes. This first one is for criminal justice, for CJ, and the second one is for sheriffs, to require that criminal justice officers not engage in excessive or unjustified use of force. So right now, the minimum standards for justice officers and don't have a requirement. You must be of good moral character or not lack moral or not have moral turpitude or not engage in moral turpitude, but there is not a specific requirement that deals with any kind of use of force. So the questions are, does this group want to consider a recommendation to the commissions, knowing the commissions would have to discuss our recommendation and then decide whether or not they wanted to enact that. Of course, they're the only ones who can change the administrative code. But do we want to recommend adding to the minimum standards that they not engage in excessive force? Same question for the decertification, revocation, or denial. So do we want to add to these two statutes for CJ and sheriffs that you can be suspended, revoked, or denied based upon a history of the use of excessive force? That's not in the code right now. That is something we could consider recommending. And then number 4, and of course you guys have all of this. This document is in the pre-work. So this document can be further reviewed at your leisure in the pre-work. Recommend that the standards commissions revise the notification procedures that currently exist in the minimum standards to require both the officer and the agency to take certain actions. And these are things that we've heard on the feedback from the task force, the feedback from the public, that people are having conversations surrounding wanting the standards division to maintain data regarding use of force, and then to deal with the wandering officer issue, requiring whether the standards commissions, we want to ask them to require that hiring agencies contact standards divisions to determine if that person has had these use of force incidents. Now, if it resulted in revocation, suspension, or denial, that information is already available to hiring agencies. So that information is already something that the hiring agency can, in fact, gain. But do we want to recommend that the commissions require the hiring agencies to check? Not all of them do that checking. So is that something that this group wants to consider? And then finally, when should the standards divisions initiate an investigation into a certification based upon the use of force incidents reported? There's not a clear-cut rule on that right now. Certainly if it was something that ends up being reported through an IA posture, that would likely come, if there's a disciplinary action at the agency, it would likely come to the probable cause committee of either commission, and then it would be started that way. But do we want to add anything into the code that says that it should come at that time? And then of course, recommend the standards division's efforts to support their efforts to creating the database where information about discipline is publicly available. The standards divisions at DOJ are already doing that. And so I think that that's not anything that is controversial, but that would be this task force recommending support for that. And then the last thing to talk about is going back over psychological evaluations. I'll remind everyone that the CJ standards. And in fact, our group, the chief is on planning and standards with me for CJ, and we are set to discuss in November the psychological evaluation issue. And so that was also on the list for next time. I think the two big ones that we want to hit next week and make sure that we get to are body worn cameras and recommendations to the standards commissions, because there's a lot of discussion to be had there, I think. So that's the preview that I'd set up for next week. You already have all of the pre-work available. This document that I've been going over with everyone, you've got in the email from me. It's also on the SharePoint, so that you can really kind of think about what your thoughts are on these issues. And certainly I'm available if there are any questions or a need for more information between now and then.
All right, thank you, Ms. Dismukes. Any final questions, guys? We'll have a robust agenda next meeting, and so we'll try to finalize a lot of these issues and push more recommendations forward. So, anything else from anyone before we dismiss? All right. Well, none been said. Motion to adjourn, I guess.
This is a whole lot of work. I want y'all to know.
Oh man, I just said that. I mean, I told Leslie that today. I mean,
I want a plaque when this is all over. A
I'm telling you,
mahogany plaque. Okay.
I'll tell my
long
boss.
leaf pine or something, Chief. You know, something. Jeez.
All right.
All right.
Thanks, everybody.
All right, y'all.
Thanks all.
Thank you.